Fellow citizen, I am coming with one more part of directive principles of state policy in the series of our constitution. Though these directives are not enforceable by the courts, and if the government of any day fails to carry out these objects, no court can make the government ensure them. Yet these principles have been declared to be fundamental in the governance of the country, and it shall be duty of the state to apply these principles in making laws. The sanction behind them is, in fact, political. As Dr. Ambedkar observed in the Constituent Assembly, if any government ignores them, they will certainly have to answer for them before the electorate at the election time. It would be a patent weapon at the hands of the opposition to discredit the government on the ground that any of its executive or legislative acts is opposed to the directive principles. The author discerns a more effective sanction for enforcement of the directives, which does not appear to have been properly appreciated in any quarters so far. Article 355 says. Whether Article 355 365 can be applied to enforce implementation of directives by the state. It shall be the duty of the Union to ensure that the government of every state is carried on in accordance with the provisions of this Constitution. Indisputably, Part 4, containing the directive principles, is a part of the Constitution. On the other hand, even though the directives are not enforceable in the courts of law, Article 37 unequivocally enjoins that it shall be the duty of the state to apply these principles in making laws. If so, it should be the duty of the Union to see that every state takes a step for implementing the directives as far as possible. Hence, it should be competent for the Union to issue directions against particular states to introduce free and compulsory education for children, or to prevent slaughter of calves and other milch and draught cattle, or to introduce prohibition of consumption of alcoholic drinks, and so on. In case of refusal to comply with such directions issued by the Union, it may apply Article 365 against such recalcitrant state. Otherwise, the directives in Part 4 shall ever remain a dead letter. Owing to the legal deficiencies of the directives and utility of their incorporation in the Constitution, which is the legal instrument, has been questioned from different quarters. Sir Abor Jennings thus characterized them as pious aspiration, and also questioned the utility of importing into India the 19th century English philosophy of Fabian socialism without the socialism. Professor Weir has criticized them in stronger terms. When one peruses the terms of these articles, or cannot deny that it would be foolish to allow courts to concern themselves with these matters. It may be doubted whether there is any gain on balance in introducing these paragraphs of generalities into a constitution anywhere at all. If it is intended that the Constitution should command the respect as well as affection of the people, if the Constitution is to be taken seriously, the interpretation and fulfillment of the general objects of policy will raise great difficulties for legislatures, and these difficulties will bring the Constitution, the courts, and the legislature into conflict and disrepute. If these declarations are, however, to be treated as words, they will bring discredit upon the Constitution also. Nevertheless, their incorporation in the Constitution has been justified by the consensus of opinion as well as the working of the Constitution since 1950. Sir B.N. Rao, who advised the division of individual rights into two categories, those which are enforceable in the court and those which were not, stated that the latter class which are known in the constitution as directives were intended as moral precepts for the authorities of the state. They have at least an educative value. The educative value is to remind those in power for the time being that the goal of the Indian polity is to introduce socialism in the economic sphere, Panikar, or economic democracy as distinguished from the political democracy, Ambedkar, which simply means one man, one vote. It reminds the authorities that they must ensure social security and better standards of sanitation, and emphasizes the duty towards women and children and the obligations toward backward and tribal classes. Panikar. Granville Austin considers these directives to be aimed at furthering the goals of the social revolution or to foster this revolution by establishing the conditions necessary for its achievement. He explains by establishing these positive obligations of the state, the members of the Constituent Assembly made it the responsibility of future Indian governments to find the middle way between individual liberty and public good, between preserving the property and the privilege of the few and bestowing benefits on the many in order to liberate the powers of all men equally for contribution to the common good. In short, the directive emphasizes an implication of the preamble that the goal of the Indian polity is not laissez-faire but a welfare state, where the state has a positive duty to ensure to its citizens social and economic justice and dignity of the individual. It would serve as an instrument of instructions upon all future governments irrespective of their party creeds. The socialistic approach has been further emphasized by the 42nd and 44th Amendment Acts as pointed out earlier. The directives are not enforceable by the court, and if the government of the day fails to carry out these objects, no court can make the government ensure them. Yet these principles have been declared to be fundamental in the governance of the country, and the government which rests on popular vote can hardly ignore them while shaping its polity. Again, while the time of the drafting of the constitution, the directives were considered by many as surpluses because they were not justiciable. The working of the constitution during the last few years has demonstrated the utility of the directives even in the courts. Thus, though the courts cannot declare a law to be invalid on the ground that it contravenes a directive principle, nevertheless, the constitutional validity of many laws has been maintained with reference to the directives so that they do not serve as mere moral homily. As Professor Weir had anticipated in 1950, for instance, it has been held that when a law is challenged as constituting an invasion of the fundamental right specified in Article 14 or 19, the court would uphold the validity of such law if it had been made to implement a directive holding that it constituted a reasonable classification for the purpose of Article 14. The reasonable restriction under Article 19 or public purpose within the meaning of Article 31. The Constitution has since been amended to dispense with the need for judicial interpretation to reach the above conclusion. In 1971, Article 31C was inserted in the Constitution to provide that law to implement Article 39B to C would be immune from the limitation imposed by Article 14, 19 or 31. In 1976, this protection was extended to any law to give effect to any of the directives studied in Part 4 by the 42nd Amendment Act, the Supreme Court has, however, resisted that extension. Even as regard fundamental rights other than those under Article 14, 19, and 31, though the directives cannot directly override them in determining the scope and ambit of the fundamental rights themselves, the court may not entirely ignore the directive principles and should adopt the principle of harmonious construction so as to give effect to both as much as possible. Again, the Supreme Court has relied upon Article 39A in determining the duty of the state in making a law under Article 21 depriving a person of his personal liberty, and held that where a prisoner has a right of appeal, the state should provide him a free copy of judgment and also engage a counsel for him at the cost of the state. Not only in the matter of determining the constitutional validity of a legislation, but also in its interpretation of statutes, the court should bear in mind the directive principles are not in conflict with but complementary to the fundamental rights, and enable the state to impose certain duties upon the citizens insofar as the directives are implemented in making a law to ensure maximum wages to workers in accordance with the directive in Article 43. Though the directive principles as such are not enforceable by the courts, of late the Supreme Court is issuing directives in proper cases enjoining the government to perform their positive duties to achieve the goals envisaged by the directives. On the other hand, the Constitution itself has been amended successively, as for example, 1st, 4th, 17th, 25th, 42nd, and 45th, 4th Amendments to modify those fundamental rights, by reason of whose existence the state was experiencing difficulty in effecting agrarian, economic, and social reforms which was envisaged by the directive principles. This is all about today's directive principles of state policy. Thanks, regards.